Hi everyone, this is Attorney Lillian with Lilly Legal, and I am here today with your Tuesday tip. So this tip really came out of having a lot of conversations with people, especially people in states where marijuana has been legalized, and how that could potentially affect their immigration status. It is a big deal. So I want you to hear me when I say it is a big deal. So even though marijuana possession might be legalized in your state. For example, I'm in Massachusetts. It is legal here to not only have possession of marijuana for personal use, but you are allowed to grow it as well for personal use. If that is your situation, I want you to realize that even though it is legal, right? That's the key. Even though it is legal, there is still an issue of what happens on the federal level, because marijuana is still considered a Schedule 1 drug under the Controlled Substances Act. So for federal purposes, marijuana possession is still illegal. Okay? If you work at a dispensary, you could be looked at as being a distributor. So again, there's different levels to it. So there's possession, there's trafficking, there's dealing the drugs. So if you work at that dispensary and you're not a US citizen, you could, for immigration purposes, you could be seen as a drug dealer. Okay, so it's really important that you know, as someone that's not a US citizen, that you cannot you are not allowed to possess illegal substances, especially if it's illegal on the federal level, even if it's legal on the state level. Okay, so it's really important, and I wanted to make sure that you know about this, because it really can derail your immigration case. So let's say, for example, you were found with, 31 grams of marijuana. Even though it's for personal use, you were still found with 31 grams. And there's some police report somewhere saying that it was 31 grams. If you are applying for a green card, you would now qualify for a green card. You will have to apply for a waiver, which means you need to meet certain requirements. And if the marijuana possession is over 30 grams, there's no waiver. So if, let's say, you had 2 grams of marijuana on you when you were arrested, you can technically apply for a waiver based on the fact that it's under 30 grams and you have a qualifying relative that can file for you. Unless, of course, it was over 15 years ago, there's a different waiver that you can qualify for. So again, marijuana possession, even if it's legal in your state, is still a class 1 drug. Okay, still a Schedule 1 drug under the Controlled Substances Act for federal purposes. Remember, immigration law is federal law. It is not states, it's federal. So if it's still illegal on the federal level, it doesn't matter if it's legal on the state level. Okay, so make sure marijuana possession, working at the dispensary, all those stuff can lead to you not being able to get a green card, get citizenship, and depending on how much you have on you, you might even be deportable. Okay, so it is important, and I hope you found this helpful. If you did, please do go ahead and share, like, and subscribe. And if you have not subscribed to my YouTube channel, please go ahead and do so you can get my additional videos in addition to the Tuesday tips and the immigration chats. So thank you so much, and I will see you later. Bye for now.